Oh, this matter, yes.
Yes.
Please, Your Lordship. This is only whether order 39 1 and 2 orders passed, whether even a writ could be maintainable, because they have to go to the MFA court.
Kindly see my prayer in the writ petition, madam.
Your Lordship, what they state is, Your Lordship, that application arbitration clause, section 8, that would have to be heard first.
ಅದೆಲ್ಲ ಅಲ್ಲೇ ಕೇಳ್ತಾರೆ.
Yes, that is a matter that they
Everything
have to
before the
raise there.
appellate
That's
court.
all, Your Lordship. That is all.
Filed my rejoinder, kindly.
No problem. I will
peruse the-
direct the appellate court to
Please.
consider all your submissions,
Please.
because writ petition without going there is not meant exceptional circumstance.
The only contention was my arbitration application has to be considered first, but by the virtue of the, as I mentioned earlier, by the virtue of the MFA order, the parties are already before arbitration. In my rejoinder,
Where is the MFA order?
MFA malos in my rejoinder.
MFA order is with
Page number
respect to.
33.
One moment.
In my rejoinder malos, page number 33.
MFA order. 20th June 2025.
Please.
ಅದರಲ್ಲಿ
Before that, my lords,
parties are before the arbitrator now.
before that, my lords, may I invite my lords to annexure T, page 30.
Hmm.
That's the memo filed by the respondents, that is Tuberali Foundation Trust, which they claim that the said
So this-
school is managed
Before the commercial court.
before the MFA court.
ಅಲ್ಲ ಅದಾಯ್ತು ಈಗ presently.
OS, original.
OS.
Commercial.
Hmm.
Page number 30, they themselves have filed a
Monthly.
memo.
Please, Your Lordship.
8, let the court first consider application 8, filed in section 8.
The parties are not the same.
If there is already an MFA order, both of you are before the
A
arbitrator.
petition is also filed, my lords.
Your Lordship,
That
what
is-
they have suppressed, just pass it on.
Suppress what?
There is a subsequent injunction. The injunction order is in my favor. So they move the court subsequently and seek an injunction. In that, there is a clear finding that they do not have any documents in their favor. Injunctions granted in my favor. They do not produce that before Your Lordship, because that is an order they cannot come before Your Lordship with. That is suppressed. With respect to MFA, that is a fee sharing dispute. That is all. And in that MFA also,
So
the
this is
parties.
squabble in the institution.
Institution fee sharing agreement only is with the dispute in that arbitration. Party also is slightly different, which is where we have sought for an injunction, because they are trying to affect our running of our school. They have brought in goons, at least 70 to 80 EDSS persons were brought in, even conducting the school activities were difficult. That is why the injunction was sought. Moment this injunction was granted, they
Intention is
have
granted in your favor.
granted in my favor. Now, what they are trying to say is, order 39 1 and 2 could not have been heard because my section 8 was pending. Rightly or wrongly, that would also have to be contested before the MFA court. That cannot be urged here. And if so, there is a subsequent order which they have passed, which the lower court has passed, which they have not produced before Your Lordship, wherein subsequent order says you do not have any documents in your favor. You have not been able to establish your rights over the property, and therefore injunction cannot be granted. Therefore, they only want to rely on this. Your Lordship, ultimately, whether section 8 should have been heard before order 31 rule and 39 is a matter that would have to be heard before the MFA court, not here, because the order is already passed.
MFA court.
They would have to file MFA, and there they can raise this issue whether this order could have been passed or not. I understand that they are trying to rely on Supreme Court judgments that say or 8 should have been heard first, but that is also an issue that they have to argue there, not before the writ court.
My lords, page number 105 of my rejoinder.
105.
105.
Rejoinder ಹಾಕಿದ್ದೀರಾ?
ಹಾಕಿದ್ದೀನಿ.
ಎಲ್ಲಿದೆ?
23rd, we have filed it.
ಇದೆಯಾ ಮೇಡಮ್ ನೋಡಿ? ಕೊಡಿ. Give the copy. You give your copy, no problem. ಓದ್ಬೇಕಲ್ಲ ನೀವು ಕೊಡಿ.
ಆ file ಅಲ್ಲಿ ಇದೆ. I'll pass this. ತೊಗೊಳ್ಳಿ. Give the source. Memo is everything.
105.
5.
But students ತೊಂದರೆ ಆಗಬಾರ್ದು. That's the only concern.
I have
Either
produced
I
the
will drive it
documents
any for
regarding
students
that
ತೊಂದರೆ
also,
ಆಗ್ತದೆ.
my lords.
105 ಹೇಳಿ.
105. If I may read, my lords.
Yes.
Prayer number 3.
ಹಾ.
That is the prayer which they have sought in the claim petition before the arbitration. AC number 309 of 2025.
All right.
to grant an order of permanent injunction restraining the respondents, that is the petitioner herein, their agents, servants, or any other persons claiming through or under them from interfering with the claimant's peaceful possession and enjoyment of the suit schedule property or dispossessing the
Oh,
claimant.
this is prayer before the arbitrator.
Yes, they have the same prayer before the arbitration. And we have a date, 29th, we have the date for arbitration. We'll have to file our objections to that.
Yes, madam.
Can I pass on, please?
What?
There is also details. There is, pass this on. Your Lordship may kindly see page 3,
Of this?
please.
Yes.
Kindly see this party that is before your Lordship.
Yes.
This is the subsequent suit file. Your Lordship may kindly see.
No,
the-
subsequent to the MFA?
Subsequent to all of it. This
What-
most recent.
No, when was this filed?
This was filed in June.
When, June? What is the date of
This
suit?
was 5th June and the order, your Lordship,
MFA order is 25th June,
20th June, my lords.
20th June.
your Lordship may kindly see this order. This is at page 60, your Lordship.
Now, what's the problem in going before the arbitrator?
Arbitrator is going on, that is only a fee sharing dispute. Your Lordship, fee share,
But why did you seek so many prayers before the arbitrator?
your Lordship, that,
Come to page 105. It is only a fee sharing dispute. Look at the prayers that are sought: permanent injunction restraining the respondent's agents, servants from interfering. Why is that?
that fee sharing dispute is between the trust.
Maybe
I'm
if
not-
it is a fee sharing dispute, who institutes
Your
this?
Lordship, that is the point. I am not the one who has gone before the injunction court. This is the principle of
Injunction
the
court
school.
Allah. The arbitration.
Arbitration, that they are trying to say the trust has the fee sharing dispute. Kindly see who is the plaintiff in the suit before your Lordship. That is different. That is the school represented by the
Now, in the
principal.
MFA where Justice Poonachar referred
That
the
is
matter,
not the school and the
who
principal.
are the parties there?
The parties there are the Turbalil Trust that has the fee sharing agreement
Correct.
and the society.
So
Now-
pursuant to that, you are before the arbitrator, this Tubrali Foundation.
Arbitrator, yes,
All right.
yes.
It is so, you are the claimant before the arbitrator. Now, the claimant seeks so many prayers with regard to injuncting the respondents even from
Kindly
entering.
see who the petitioner, the plaintiff is. It is not this trust.
My lords.
Which plaintiff before the civil court?
Plaintiff
Now,
before the
in
civil
this-
court, please.
Who is the plaintiff here?
Plaintiff is represented by the principal, that is the school. So inter se, the society and the school will have to decide. It is not the problem here. Now, what has happened is the principal has gone only with respect to the persons who are troubling. Kindly see page 61. Kindly see page 61,
Of the objections?
please.
Ah.
Memo along with documents that's
Yes,
filed. Your Lordship.
61.
61 is this latest order passed in 3935.
Hmm.
At para 14.
Hmm.
This is the order that they've come before is the order that was passed prior. Now, this is the subsequent order. After a minute scrutiny of the material and records, it's material to note that the defendants arraigned in the above suit are claiming to be administrative staff of the trust, but the plaintiff has contended that the defendants are unconnected with the functioning of the school. Meanwhile, it is noted that plaintiff society itself has admitted OS 3563 was instituted by defendant number 1 claiming to be the principal of the school run in the suit premises, and D3 has lodged a complaint in crime 168 of 2025 in connection with the affairs of the school. Defendants have produced the copies of ID so and so, so and so. Lordship may kindly see page 63, internal page 23. The relevant portion starts at line 4. However, it is pertinent to note that in the present suit, plaintiff has categorically pleaded that the fee sharing has been terminated and plaintiff society has re-entered the suit premises, but surprisingly, no specific details and material particulars of the termination of the fee sharing agreement are forthcoming from
What
the
is
records.
this writ appeal 740 of 2025?
That was again filed by them, Your Lordship.
My lord.
Your Lordship, at every stage when there is an order, an appeal is gone to. Again, MFA they've gone to. Even in that order passed by Justice Poonachar, what they had pleaded that until such time that they go before the arbitration, recognize that I can run the school, which was not granted. Therefore, these are different ways to come before to enter the premises to run the school. The dispute can go on as to who has to run the school, arbitration can figure out. But till such time, the principal has sought that allow me to run the place since Parents have a problem, children have a problem, so they are trying to run the school without difficulty. Continuously, we have had problems with people coming into the school. Your Lordship, I shall just continue this portion. Photographs relied on by the plaintiff do not establish school as being run by the society. This is an observation.
So the court goes by the photographs.
No. All the documents, Your Lordship, might I go 2 lines before? There are no materials to show that the following termination of the agreement, plaintiff has admitted the students the name of the society and has been running the school independently. Not an iota of a document has there. Might I also show, Your Lordship, this is not the one, where they have, no. There we show we are running the school, the details of the fees. Where is it?
Statement of objections.
Give them. This is filed already. Your Lordship, statement of objections. Your Lord, this is not the memo of documents.
Statement of objections also here.
Please.
Yes.
Lordship may kindly see the last few pages. Annexure R1. Your Lordship may kindly see this at page 100. Professional tax returns being paid by that foundation. The previous page R10. Transactions with ESIC. Those are being paid by the trust. Please. Now your Lordship may kindly see in their writ petition itself, the first thing that they state is they had terminated in 2001-2002. One document to show from 2001 to 2025, if they had already terminated and nobody is in, they would have been collecting the fees. They would have been paying the ESIC. They would have been paying the tax, not one document. Therefore, when there was not one document produced before the lower court, they denied them an injunction. Therefore, now they're trying to state that, no, our arbitration is pending. Your Lordship, also Supreme Court is very clear. Injunction can be continued. You can move the civil court if there are different parties, but it is arising out of a similar transaction. Now, your Lordship may kindly respond, defendant number 3 is not part of the arbitration. Here also, your Lordship may kindly see, I have
Defendant number 3. Who's defendant number 3?
Defendant number 3 is part of the school, who is the estate manager who is running the school. None of them are part of the arbitration. Here is the issue of whether the day-to-day activities of the school.
Trust is running the institution.
Trust is running the institution.
You are a part of the trust.
No.
Then you are independent of the trust.
The school run by the principal is separate entity as a.
School has not taken birth by the principal. It is run by the trust.
No, there is again a problem because they say it belongs to their society. So then it has to be decided whether it's the society or the trust. Until such time when their disputes are solved, the principal would want to run the school. Injunctions only to restrain any person from interfering. That is all. How is that going to come between the issue before the arbitrators, your Lordship? Arbitrators is going to decide on the issue. Now, an injunction's been passed, rightly or wrongly. Whether I am to come before a writ court or I am to go before an MFA court is the issue. Even with respect to section 8, they would have to urge that it would have to be probably sent back. Now there are 2 FIRs also as against this person. Last time
FIR is not the subject.
No. As I had explained on the last occasion, your Lordship, these are 2 adjacent schools. The person who is running National Public School on the adjacent property is attempting to take over this side of the property.
No, we are not on that. We're only on the technical issue. Whether
Technical
it
issue,
should be entertained
please.
or not.
Please, that is all.
And
Fine,
what,
madam.
madam? Anything?
Page number 81. The cause title of the OS itself says that the
Page 81 of?
81 of the petition, my lords.
Is a rejoined. 81 of the petition, is it?
Petition. The cause title, my lords. The cause title itself says managed by Tuberali Foundation Trust.
81.
81. Sharda Vidyaniketan Public School, managed by Tuberali Foundation Trust.
Defendant number 3.
Principal Hakila.
This writ appeal is police protection.
Police protection.
All right. Yes.
It was
Their
ordered that
injunction
the
was
police.
dismissed, they went there. Police protection was one of the other issues.
my prayer was
Injunction
not-
was
please,
dismissed,
my
they
lords.
went there,
Writ
your
appeal
Lordship.
ಹೆಂಗ್ ಹೋಗಕ್ಕಾಗತ್ತೆ madam?
Please, my
Injunction
lords.
Your Lordship may
My
kindly.
interim prayer was not considered. That is the
I'll read
reason
that
we had approached the writ appeal court. where
Interim prayer here, writ petition was not considered, so
considered.
writ appeal is filed.
The
How is
Lordship, might I-
injunction be challenged
Your
in writ
Lordship,
appeal?
might I read that portion? Counsel for the state submits is no order passed by any court direction given to enter the premises of the appellant institution.
And the court directed the police to
Yeah.
vacate the premises.
1 minute. If there's no specific direction
It
from
was
any
against
court.
an against a GM order, is it? In an order in GM.
There was no order, my lords.
Police take possession of the property.
The police.
Set aside the order
lords,
six
all
passed
of
by
a
the Learned
sudden-
in WP 13868.
My lords,
TM
all of
police.
us.
Now,
GM police.
please, there are different ways in which they are only trying
That's
to
okay,
enter the
but
premises.
that-
Now,
that's a
every
submission I'll
single
answer.
order that has
But
gone against.
injunction ಅಲ್ಲಿ ಆಯ್ತು ಅಂದ್ರೆ ಆಗಲ್ವಲ್ಲ. Division bench was not hearing the injunction.
It was only on
Police
the
protection.
police
Might
protection.
I read? The pastor?
Police protection.
Your Lordship set of
My lords, all
memos
of a
was-
sudden
Jade.
on 2nd May 2025, 30 to 40 police personnel were deployed in the premises. We challenged that in the writ petition, my lords. My interim prayer was not considered. It was a vacation bench. I had to prefer a writ appeal. In writ appeal, I got an interim order on 8/5/2025 stating if there is any such order by any courts,